Good afternoon, everybody. Welcome. Thank you very much for joining us for slightly different, one of our CPD microburst sessions this afternoon, but something that we felt it was really important to do as a kind of a rapid response to some of the things that are going on in the veterinary sector at the moment. So what we wanted to do was put on a series of sessions aimed at helping you to navigate redundancy. So the series that we are running, we've got our first one this afternoon. I'll introduce Kat in just a second. We've got the second in the series is next Friday, where we will be joined by a senior advisor from ACAS. And then the third session will be the following week, when some of the fabulous folks from Vet Stay Go Diversify will be talking about marketing yourself in the jobs marketplace for those who have been affected by redundancy. So we've got hopefully some really useful, really practical sessions for you over the next few weeks. Thank you very much to everybody who sent their questions in. We'll hope to get to as many of them as we can. The comments on all of the platforms that we're streaming live to today are also open. So if you have any additional questions, comments as we go, please do pop them in the chat boxes and we'll bring them up and we'll try and get to as many of them as we can. So for our first session, we are looking at navigating redundancy from an employer's point of view. So this session, we're going to be looking at it from the perspective of employers, leaders, managers in the veterinary sector who might be involved in redundancy processes. And to help us with that, I am really, really pleased to introduce the lovely Hare, who is a solicitor at Citation, who works in employment law. So, Kat, thank you so much for joining us.
Thank you for having me. Good afternoon, everyone.
Hi. So, as I said, we've got a lot of questions this afternoon. So we're going to jump right in. So we're going to start, we're going to channel our inner Simon Sinek and start with why, because the first question I thought would be interesting to start with is just why. So it's not something that we tend to see in the veterinary sector, but why might an employer be considering redundancies in their company?
I know, and you know, hopefully it's something no one ever has to deal with. But you know, it's a case of if as a business, you know, you're seeing you know, increased energy bills, things like that. The cost of running the practice is becoming unsustainable. It may be that you have to think about, well, do we need to make some redundancies to make the business viable going forward? But when you think about redundancies, there is a very strict legal definition of it. So sometimes you may be thinking, oh, perhaps we could move things about to try and make things more efficient. That's very different to a redundancy situation. In the Employment Rights Act, it specifies that the three situations when a redundancy situation would occur. And that's when you're actually closing a whole business, you're closing a place of work, or there is a requirement of the business for employees to carry out work of a particular kind has diminished or ceased. And it's that last section which I think we advise most on, is where there's a reduction in work of a particular kind. So to put it in context, you know, if you've got, for example, you know, 5 equine vets, but actually the amount of equine work you're doing has reduced significantly because people can't afford to keep horses anymore, for example, and perhaps you're thinking, well, actually, perhaps I only need 2 now, that would fit in that last definition. So it may be that you're thinking, well, actually, we can't sustain having that many people in that department anymore. The particular work is the equine work, and that's really, really diminished. So actually, we need to then look at making redundancies. And that's kind of the situation which would fit within the legal definition and would then mean that you have to go through the process with regards to redundancy consultation, etc. And then it would result in 3 people losing their role due to redundancy. So there's the kind of situations that would kind of fit in the redundancy definition from a legal point of view.
Right. Yeah, that makes sense. I think that's what we've been talking about. Well, like, for example, if you have a mixed practice where perhaps the large animal work is dwindling and the focus is more on the small animal, then perhaps you might be looking at that kind of thing. Okay, lovely. That gives us a sort of a context to why this might happen. So the next question is kind of what, again, us in the veterinary sector, we're not really familiar with redundancy processes. So can you just give us an overview, like what can people expect if they are involved?
Yes, so with regards to redundancy, again, it is quite a complex area, really. So there are obligations on an employer if you're making a certain amount of people redundant. So if you're making 20 or more people redundant in one establishment in a 90-day period, which is quite wordy, but effectively, 20 people in one establishment in 90 days, then there are very strict requirements about what you do, because that's called collective consultation. So hopefully this won't happen, but this is quite large scale redundancies. You've got to fill in a HR1 form, you've got to tell the Secretary of State what you're doing, and then you've got to consult for a set period of time. So if you're making over 20 people redundant, but less than 100, then you've got to consult for 30 days before you make that first dismissal. So it's very strict. In a situation where it is perhaps, three or four people that you're thinking may be redundant, etc., then there isn't a set time scale. But what you need to make sure is you consult meaningfully. With that, you've got to demonstrate that you've warned people that they may be redundant, that you've consulted with them, that you've kind of warn them of what the selection is. So if you're going to go down from 5 to maybe 2, you've got to think, well, how am I going to select these people for redundancy? And then you've got to make sure that you give them a right of appeal should they then be dismissed for redundancy. So with regards to required steps, it's only if you're making a significant amount of people, redundancy, you've got this collective consultation, but there are a requirement in the sense of you need to make sure that you follow a process where people feel like they've been consulted with. And it may be that individuals can think of ways to avoid redundancy, which you may not have thought of. So it's a case of saying, look, this is our situation. How can we avoid it? What can we do to try and resolve this situation before we can try and avoid redundancies? And I think that needs to, I think the next question, kind of leads on to that, I suppose. What right. Must tell employees at each stage. That kind of fits in with the consultation process, really. So it is a case of, depending on the situation, the amount of meetings that you have will differ. So if it's a whole business closure, the process can be perhaps a little bit quicker, because you will have an announcement meeting, you will have probably a couple of group meetings to say, look, this is what we're doing. Unfortunately, we're in dire straits. You would then have an individual meeting, and in that case, you haven't got a selection criteria to kind of discuss, because it is just the business is going. But of course, if we have the case where we're having to, we've got a pool of people who do a particular work. So in this case, equine, for example, or large animals. If it's a case, then you've got to think about, well, how do we select? What do we do? That process does take a little bit longer. So we'd always suggest that you'd have your business case. And that's the absolute cornerstone of a redundancy process. We would always kind of ask our clients to say, well, look, what is your business case? Put it down in writing for me so we can see exactly why you need to think about making redundancies. And that's really helpful, because it acts as a script as well to kind of set out, this is why we need to do what we can do. And, from experience in tribunals, if it's going down a redundancy process and that's been challenged at a tribunal, the first thing an employment judge does is has a look and says, well, what was the business case? Does this make sense to me? An employment judge would never kind of interfere with the business case. They would never say, well, do you know what? I think you should have kept the equine vets. And, I think you should have reduced your small animals offering, because that, to me, I would prefer there to be more equine vets. They would never look into it. They would never look into it in that depth. If it makes sense, then they will go with it effectively. What you can't do is say, we have to make redundancies, and then you've got a balance sheet where you've got hundreds of thousands in the bank. That wouldn't make sense. But as long as you can say, look, we've seen a massive downturn in work, we can't sustain this for much longer, and we need to think about reducing headcount here. This is why. So we would always say, put the business case together. Then you would have an announcement meeting to kind of discuss the business case with those people who are at risk. Explain to them the rationale, I suppose, behind it if this is a situation. I think most people probably expect it when the announcement meeting comes, because they've kind of realised perhaps they've been twiddling their thumbs a little bit, or perhaps not being, as busy as they've been previously. And then we'd say you'd have probably 2 to 3 group meetings with individuals where you kind of say, look, can you think of a way of avoiding redundancies? Please come to us. I suppose you could ask for volunteers as well. It may be that some people have thought, well, perhaps I wanted to go travelling, or perhaps I wanted to take some time out. They may volunteer. And then you can explain in the group meetings as well, this is how we propose to select people for redundancies. Has anyone got any questions about that? Do you think this is a fair consultation process, do you think is the fair selection criteria? So it's kind of just showing that you've demonstrated you've consulted with individuals and given them the opportunity to put forward suggestions as an alternative. So it may be that, if we're going from 5 down to 2, they all may club together and say, well, actually, we all kind of want to do different things, have more outside interests. So actually, we will just reduce our hours. So we just amount to 2 full-time employees, but actually we're going to split it between ourselves. You don't know, sometimes there's been some quite inventive suggestions that employees have come back with to say, look, we want to try and avoid a redundant situation. We're willing to do X, Y, and Z, which have been, really well received by the employer, and they've avoided a redundancy situation. So that's the whole point of the consultation. But then you would, of course, at each stage, you'd be telling them kind of where we are in the process. You would then score the individuals using your selection criteria, and you'd have an individual meeting with them to say, well, look, on the basis of the scoring, you have been provisionally selected for redundancy. Do you agree with these scores? If you use a transparent and clear process, then there's going to be little wriggle room, but it's showing them how you've been scored. And then the final meeting would be then to issue them with the redundancy notice to say, you have been selected for redundancy. You would need to work X amount of weeks notice, and your redundancy pay will be X amount. So it can be quite a long process. I think it's a case of, it's just demonstrating that you've engaged in the process, you've consulted, and that you've really shown the individuals this is what we're going to do. We're being transparent, and if individuals do come back with queries, questions, that you deal with them as well. You don't just say, well, that would never work, we're moving on. It's a case of saying, well, okay, would the 5 down to 2 work? And if they all split their hours between each other, or would that not be consistent enough? Perhaps you need consistency in that kind of field, which I imagine you do. So there might be an argument about that. But yeah, it's showing that you've kind of thought about it, and you've explained why or why not it may work. I think as well, just think about redundancies. As a business, it's worthwhile thinking about how you've tried to avoid redundancy. So in a business case, you could say, look, we have thought about, short-time working, or perhaps temporarily laying people off because actually we think there might be an upturn, in a couple of weeks, etc. So it's kind of showing how you've thought about how can we avoid redundancies, what have we done already, and kind of demonstrating that, we are left with no alternative now. So I hope that's helped. I know it's quite a long process, but it's just worthwhile kind of saying the steps, kind of what a tribunal, I suppose, would expect to see, just that you've really engaged individuals in the process.
Yeah, that's really interesting, because I think that there can be a bit of a sort of perspective that, one of the questions that we had.
Yes.
Mine's already been made up by then. So it's really interesting to hear that there is the option for people who have been told that they might be at risk to actually come up with alternatives and say, well, actually,
exactly,
if we decide to do a job share or reduce hours or move over to the more side, or
volunteer to leave because I've been thinking about that for a while, or something like that. Yeah, it's amazing that you might not have thought somebody was planning to go traveling, but they may very well, that might be their opportunity to go.
Right.
So, but I think, like I said, I think this question is really important, because, like I said, it's having this meaningful consultation, really, isn't it? Not closing your mind to think, well, it would never work. And also, as well, I think sometimes, a company may think, well, I think this person's going to leave from redundancy. There's 5 people, we need to go down to 2. I know which ones are going to go. You need to make sure that doesn't happen, that actually you can demonstrate you've had a fair process and you've used a fair selection criteria, not one that kind of gives you the outcome that you think you might want. It's kind of demonstrating that, it's fair and reasonable and how you've reached that decision, because sometimes, dismissing somebody for performance, etc., can be dressed up as a redundancy, but that would be seen through a by tribunal if you've used quite arbitrary selection criteria to the people that you want to leave kind of leave. So I think it's a case of making sure it's fair and transparent as well.
Yeah. Is there any relation when we're talking about selecting people for redundancy? Is there any relationship between the length of time they've been with the company, or is it purely on the criteria?
So you've got to really think about selection criteria. So I did print off actually this selection criteria that we kind of got as a precedent one for clients at Citation, and we look at for example, these are suggestions. So it's obviously up to a client to kind of decide what they think is appropriate. But for example, look at disciplinary record, attendance record, lateness record is another quite good one. If you've met targets, so if you had certain targets, that's also quite good. And also qualifications, and kind of you can weight these weight these as a criteria. But I think it's really important you don't use anything that could potentially be discriminatory. So for example, length of service. Would younger people be able to kind of have the length of service that an older person might have? So using things that are very tangible, clear, things like disciplinary record, lateness, etc. They are it's very difficult to argue on those unless someone, for example, is late because they're suffering with a disability and they struggle to.
Well, that's what I was going to say. So you've got the risk there of
I know.
so you that kind of thing. Yeah.
So I think this is probably where we see most people tripping up with regards to selection criteria, where they've used something which then they haven't realised perhaps would mean that you're discriminating against somebody because of that. But then you would hope when you're consulting, you would say, look, these are the criteria. You would hope at that point an individual will say, well, hang on a minute, I am late, but that's because of X, Y, and Z. So then you can think, right, okay, well, we won't use lateness, we'll use a different criteria. So yes, it is really important to make sure if you're using any criteria that there isn't a risk there of discrimination. But like I said, that's where the consultation is really key, because if everyone's saying, yeah, happy with that seems logical, that seems fair to me, it is what it is, then you've got that in writing, and that's really useful, and to rely upon that going forward, where everyone said, yeah, happy with that. Yeah, so that's why it's useful, certainly.
Lovely. Yeah, that makes sense. Okay, lovely. Thank you. Okay, a couple of just kind of definition questions that have come up of some things that might form part of a redundancy process. So, firstly, what is garden leave? Or garden leave?
Yes, gardening leave. So garden leave is when the employer sends the employee home on full pay during the employee's notice period. So it's during notice period. So we do get some calls from clients to say, I want to put someone on garden leave. And, there hasn't been a resignation, there hasn't been a dismissal. So, you wouldn't be able to do that, because that would just be sending them home for no reason. So it's during a notice period. So normally in the citation contract, there's an express clause which says, during a notice period, we have the right to put you on garden leave and not provide you with any work, because of course the issue is that as an employer you have an obligation to provide work to an employee, and they have an obligation to do it. So this is kind of going against it, really. So it's handy to have an express clause to say that you're on garden leave. If you don't have the express clause, then you can agree that, and some employees would quite like, I suppose, a period at home on garden leave. If it's a case of, it's been a quite contentious situation, and an individual's been dismissed and they're having to work notice, and they perhaps want to go to a competitor, they're not going to particularly want to spend a period on garden leave. So that's certainly something that's open to companies to do. Most companies would use garden leave if there's an issue about competition. So if you're worried about somebody taking people with them elsewhere, obviously, hopefully you've got restricted covenants in your contract. But if not, or even if you're worried about people them saying, no, I'm leaving, actually, do you want to come with me to my new practice, or setting up on my own, or things like that, you may want to get them out of the business, and for them not to be contacting clients during their period of notice if there is that risk. So that's kind of when people tend to use it. Right. But hopefully, if you have a look in your contracts, if there's a clause in there, that's really useful, so you can just rely upon that.
Yeah. Okay, lovely. That's very clear. Thank you. I love the idea of it actually being a period of time where you go and do gardening. Is that where the name is?
I think it did come from that.
At home for a couple of weeks and watch Wimbledon.
Yes, I know.
Okay, and I feel like I'm putting you on the spot with like fingers on buzzers here. What is a compromise agreement? So I think those two words kind of make sense, but I presume there's a specific definition.
Yeah. So compromise agreements is how they used to be described. So now they're called settlement agreements. So they changed the name effectively. So they're now called settlement agreements, but a lot of people do refer to them as compromise agreements. Right. And this may be where, if you're thinking about a redundancy situation, but you're thinking, well, actually, rather than go through the whole process, I would like to approach someone to say, how about you, I give you a bit of extra money, and, you perhaps move on, perhaps if they want to go traveling, or if you're thinking about doing something different, perhaps. Mm-hmm. So you can have what's called a section 111A conversation. It's called a protected conversation. So you could say to an individual, look, I'm thinking that there might be a downturn in work here. if I offered you X amount of money, would you want to accept that? And then if they do, then you can tie it up in a settlement agreement. Now, you can only have these protected conversations with regards to claims for ordinary unfair dismissal. So if there's elements of discrimination here, or there's some underlying issues, for example, there's been performance management issues, they've been raising grievances, etc., then section 111A would be risky to have that. And I think what we always say to clients, if you're going to do it at the beginning of a process, you've got to have a contingency, because if you offer the individual that and they say, no, I'm okay, thanks, I'm very happy here, I don't want to leave, and then we go down a redundancy process and then they're chosen for redundancy, they may very well think, well, was that not a foregone conclusion already? It may kind of make it a bit more contentious than it needs to be. So we see settlement agreements used quite a lot at the end of the process, where clients, obviously don't want to lose people. This has been forced upon them, but they may want to give a little bit of an enhanced payment just to kind of send them on the way. So if, obviously you've got the statutory redundancy pay, which I think we'll look at shortly. Yeah. But you may want to give an enhancement to kind of, as a goodwill gesture. And you can then tie that up in a settlement agreement, because what you don't want to do is give extra cash and then they then just go on bring a claim against you and you've given them extra money for nothing. So you can then give them extra, you can have a protected conversation with at the end of the process to say, look, we really value all of your service and your hard work, and we want to give you an extra sum. We're going to tie it up in a settlement agreement. The individual would then take that to an independent solicitor to get it all signed off. But in that situation, I can't see there being a massive issue, because they're just giving them a bit of extra money, but then you would have to pay for them to go and see that solicitor just to tie it all up. But they're kind of the settlement agreement. And I think I've probably not touched on what actually we do. So settlement agreements, actually, they would then stop an individual from bringing a claim against you. So you'd give them a bit of extra money. They would go to a solicitor. A solicitor would say to them, look, you've got this agreement. It says that, by accepting this money, you're then not going to go to a tribunal. Are you happy with that? Generally, if the process has been, if it's inevitable, I suppose, what the outcome was going to be, an individual will say, yes, that's absolutely fine. I just quite happy to have the extra money and go. And then it's all signed off and then that's tied up. So it just means that you're protected, I suppose, and that they're not going to turn around, a month down the line and say, actually, thinking about it, I don't think I should have been selected. You don't have to pay to go to an employment tribunal. So potentially you could then bring a claim at employment tribunal and query if it was a genuine redundancy or not. If you've got a settlement agreement signed, then of course you wouldn't be able to, because in the agreement you're saying, I'm not going to bring a claim against you. Right. So that's kind of how they're used. So they're used as a protection almost for the company. But like I said, it's important that if you are having these protected conversations, you get the timing right. Because like I said, if you have them, when they're employed at the beginning of the process, and it may then make the individual feel a bit more hostile and they may be more difficult to manage, if they don't agree to it. So it's worthwhile just thinking about, are they going to agree to it? Is what you've offered attractive enough, I suppose, for them to sign up to an agreement? Okay. So, yeah. That's really interesting.
And with this kind of settlement agreement, is that always initiated by the employer, or could it be suggested by the employee?
Well, it may be. I mean, it's always quite useful if an employee suggests it, because then you know that they're quite willing to accept it, I suppose. Right. So it could be an employee that comes to the employer to say, look, you've had the announcement meeting, the redundant is clearly a redundant situation here. I'm thinking that I'm thinking about volunteering actually to go, rather than going through the process. You may want to say, well, actually, okay, well, should we have a protected conversation, and then we can agree kind of signing a settlement agreement perhaps, and we'll give you a bit extra. Or an individual could just come to you out of the blue just to say, look, if you give me a bit of extra cash, I might get, I'll leave, and that may help with your balance sheet. So it may be that, like I said, and you keep using an example, but if, you've got the 5 equine vets, one of them thinking, there's not much work actually, I am thinking about going traveling, they may very well approach and say, look, I don't think there's much work, I'm thinking about going, but if you could give me a bit of cash so I can buy my plane ticket, I would quite like to go. So it may be that situation that would be appropriate then for the settlement agreement to be signed. Right. So yes. So there's lots of different situations where they can be used to be effective. But like I said, you need to make sure that if you're going to go down that route, you are going down that route, and you're kind of confident that there's going to be some kind of acceptance.
Right. Yeah, that makes sense. Well, that actually leads us on quite nicely. Let's talk about the money.
Yes.
Because again, it's a question that comes up quite often. So how are redundancy payments or settlement or whatever they're called? How is the money worked out in a redundancy situation?
Yes. So with regards to redundancy payments, there is a very set criteria, I suppose, with regards to working them out. So there's statutory redundancy pay, which is 1.5 weeks pay for each complete year of service after reaching the age of 41. It's 1 week's pay for each complete year of service between the ages of 22 and 40. And then half a week's pay for each complete year of service below the age of 22. So there is a calculator that you can use, because it is quite set criteria. The maximum amount of weeks that can be used to calculate redundancy pay is 20 weeks effectively, and there's a statutory cap as well on the amount of a week's pay. And that is currently £643. So the maximum amount that somebody could get by way of statutory redundancy pay is 19,290, if my maths is correct. So there is statutory caps on that. So it's like there is a calculator that you can use if you have a look down the Gov website. There is a statutory calculator that can be used. But yeah, there is a very set redundancy payment formula. But then, of course, like I said, with regard to settlements, you can offer enhancements. So if it's a case of you want to offer an enhancement, you may very well tie it up in a settlement agreement because you're giving some extra money, and an employee will then hopefully agree that they're not going to bring a claim on the basis that they're getting some extra cash for that. Right. I think it's important to make sure you're really clear of what your terms and conditions are, because it may be that you have a policy that has an enhanced redundancy payment in. You may never have gone through a redundancy process before, and hopefully not, and hopefully you don't have to. But it may be that especially if employees have tupied in on different terms and conditions, it's really important that you have a look just to check. Well, if I did make them redundant, what would I pay? Is it statutory, or actually, is there a situation where I have to pay an enhanced contractual redundancy payment? So it's worthwhile just having a quick look at the contract to see what that says.
That's a good. Actually, links in one of the comments we've got. Actually, someone's asked, like, how does it work with TUPE? So presumably, if people have come in on previous contracts.
Yes, exactly. And I think from a TUPE point of view as well, I think it's worthwhile mentioning that if, for example, you decide that you want to, your equine function isn't your equine part of your business isn't functioning very well, it's going to be taken over by somebody else, and that part of the business moves to another provider, perhaps, then that very well may be a TUPE transfer and not a redundancy, because actually those who are assigned to that part of the work would move with it. So so we sometimes get calls on the advice line to say, I need some help about redundancies, but actually when we dig into it and we see the business case is that actually we're going to carve out this part of the business, and then the neighbouring practice is going to take that on, because they actually have a lot of capacity and need those individuals. So then that would be a TUPE transfer. So it's really important. That I said the business case is really, really important, just to kind of get it down on paper as to kind of what you're doing. Is it a case of you need to reduce headcount, or is it a case of perhaps you're selling part of the business or anything like that? Because then that will be TUPE. But yeah, TUPE is relevant as well. As if you've had people TUPE in historically, they will be on different terms and conditions. So double check those.
Right. Yeah, it could be quite a relevant one with the current situation as well. So looking at specific contracts. Okay, so let's carry on around sort of redundancy agreements. We've got to the point where we're sort of negotiating, I suppose, with people who are whose role have been flagged as being at risk. So this is one of the questions that has come in advance. Can redundancy agreements be changed or retracted? So I'm not sure. I presume that means not once they have been agreed or signed.
Yeah, well, I mean, I think so. If you make someone redundant, so you would have your meetings, have that final meeting, say, look, you're going to, you have been selected for redundancy. They would then have to work their notice. So they would have notice in their contract, either statutory notice or more notice. So they'd probably have to work, 4 or 5 weeks, depending on their service. And if in that time you then get a massive influx of work, the fact that they've been given that notice of redundancy wouldn't mean that they then had to be made redundant, because actually you could say, well, actually I'm going to rescind that notice now because we're inundated. That we didn't expect to see this, but actually we have got like loads of work in that we weren't expecting. So an individual would then effectively not be redundant. But there was a case on this which I was having a look at because it rang a bell, this question. So I thought there was a case that I looked at recently. So it's the case of Gregory against Hanning Limited, which I'll just kind of explain to you kind of what happened, I suppose. So this was a small mining company, and they gave notice of redundancy to all their employees, but made it clear that they hoped to kind of find some work in the future. Now, in that case, our advice would have been, well, it would have been sensible to lay them off, really, because if you thought there was going to be some work coming in shortly, if you've got a layoff clause in your contract, a layoff would mean that actually they can just temporarily be laid off. When the work comes back in, you can just bring them back in rather than make them redundant and then be completely dismissed from your business. But anyway, they didn't do that. So towards the end of the notice period, the work picked up. And Mr. Gregory was told his employment would continue, and that, they thought that his job was going to be safe going forward. But Mr. Gregory said, actually, I'm rejecting that offer because I'm right at the end of my notice period and I've got a new job elsewhere. And the company said, well, actually, you're acting unreasonably. We've got work here. We're not going to pay you your redundancy payment because you're not redundant because we've got work. And actually, he went to tribunal and they said that actually, no, he didn't unreasonably reject this offer of staying with the company, the mining company, because actually they said that he'd endured 2 months of uncertainty. The future of the company remained in doubt. And actually, the new employer that he'd found seemed to be a much more stable company, and most people in the claimant's position would have done what he did. So actually, he was entitled to redundancy because actually he didn't unreasonably refuse that. So I think it's a case of what you don't want to do is think, oh, we might have some work coming, because when you give them notice of redundancy, that is quite a draconian step. And people will try and find work elsewhere, and they will leave. They probably won't work the notice period. I imagine people will just think, well, I need to pay the mortgage, so and I'm just going to go. So I think it's a case of if you make someone redundant, you've got to be pretty certain that's what you want to do. But obviously, in the notice period, if a job does come up, and people have struggled to find work elsewhere, then because they'll be super keen to stay with the business. But I think it's a case of if you're going through the process, you need to be really clear about what you're doing. And if it's a case of you think we might be getting some work in actually in the next couple of weeks, if you've got a layoff or short-time working clause in your contract, utilise that instead, just to kind of tide you over, rather than going through the whole redundancy process and then realising a couple of weeks later you haven't got enough people to do the work that you've got in. So I think that would be the situation.
Right. So a redundancy agreement, it can be retracted, but the employee isn't obliged to accept the retraction, I think was the gist.
Well, that was that case where it was all about if it's reasonable. Did they unreasonably refuse that new offer, that work of continuing work? Did they forfeit their right to redundancy payment? The tribunal said, well, no, because actually, it wasn't reasonable to expect him to kind of wait right till the end before looking for work, because obviously we've all got outgoings, etc. I think if the settlement agreement has been signed, then that can't be retracted. Once you've got a binding settlement agreement, signed by a solicitor, signed by all the parties, then that's a binding agreement, and that would explain when the termination date, etc. is. You wouldn't then be able to retract on that. That would be a binding agreement.
Okay. Can we just, I'm not sure if people might be a little bit more familiar about the concept of layoff from COVID, but can you just give us a quick overview what we mean by layoffs or short-time working agreements?
Yeah, so I mean, with layoff, that's when you kind of lay people off for a period of time with no work, with the prospect of work coming in the future, I suppose. So if you know that perhaps you've got a lull, but you're going to get a lot of work coming, you're going to have a really busy Christmas period or something like that, then you could lay people off. But the idea is that there should be some work on the horizon. It shouldn't just be for forever and a day. it should just be a very temporary measure. Short-time working is a reduction in work where the remuneration for any week is less than half a week's pay. I just looked that up before we came in. So there is short-time working as well. But what I would say is that you need to make sure it's in your contract if you are going to be looking at layoff and short-time working. It's in the citation contracts. If not, then again, you need to kind of get agreement to it, and people are perhaps reluctant to do that because it's, especially with layoff, you get what's called a statutory guarantee pay, but it's not that much really. Right. So yes, they are something to think about if you're thinking about a short-term solution. But it needs to be very short term, I would say.
Right. Okay. Lovely. Thank you. Another question around notice. This seems quite a big topic that people have questions around. And this is an interesting one. So if an employment contract notice period is longer than a redundancy notice period, which takes precedence?
Well, they should both be the same, is what I would say. So with redundancy, that's a dismissal. So effectively, whatever's in your employment contract about notice, it would be the same whether they're dismissed for redundancy or for their conduct or performance, etc. So it's all the same effectively. So it wouldn't be different, and it would just be what's in the contract. So they would be it would be the same. It would be a case of whatever the situation is with regards to dismissal, what the contract says, you would follow that.
Okay, so you couldn't issue a redundancy notice that was for less than your standard employment contract?
No, it would be what's in your contract. Yes. Yeah.
Unless, you could override that with a settlement agreement.
Yes, so if an individual kind of is going to leave straight away, you could do that in a settlement agreement, and then within that settlement agreement there would be, the redundancy payment, perhaps an enhanced payment, and also a payment for notice would probably be within that settlement agreement as well, to reflect the notice period that they should have worked or should have had from the employer.
Right, that makes sense.
Yeah.
Okay. Okay, lovely. So we've whizzed through a lot of questions there. If anybody who is watching live does have any additional questions, then please do pop them in the chat. I'm just going to flag our next session, which is, like I said, next Friday. It'll be on the 14th, same time at 1 o'clock. We'll be looking at navigating redundancy, but we're going to be looking at more from employee and colleague points of view. So we're going to have an advisor from ACAS joining us to do a very similar thing, just to answer a lot of questions that we throw at them. So do join us for that if you are affected, or even if you're not directly affected, if you just want to learn a bit more about the process, about what's going on, about what's involved. It's always useful to have a better understanding of these things and how we can support our colleagues. We're a small profession, and we know that these kinds of things happening affect everybody, whether or not you're directly affected or not. So it's always good to get a good understanding of these things. So do join us for part 2 next Friday, 14th of July at 1 o'clock. Same on all of our live streams. But apart from that, I'm just going to say a huge thank you to Kat Hare for bringing her expertise along, for answering all of our questions. It's been massively useful, really, really interesting.
I hope so.
Great to have quite a complicated subject explained by someone who knows their stuff and can put it into words that those of us who are really unfamiliar with this kind of area of employment can understand. So thank you very much to Kat. Thank you very much to Citation for their support of this session. Any ongoing questions, do again continue to drop them in the chat.
Please do.
As kind of BMG, and I'm sure Kat will be fine, to help support, answer any questions, whatever we can do to help, we will do our best. So thanks ever so much, everybody. Thank you for joining us this lunchtime. I hope you have a lovely rest of your Wednesday. Quite for a second. Do join us next time, and we'll see you then. Thanks ever so much.
Thank you. Bye. Bye.